Welcome to the latest instalment in our series of webinars from Doughty Street Chambers Housing Team. This time we are talking about avoiding eviction at the warrant stage. And to let you in on a little secret, this wasn't supposed to be the topic of our webinar. We were supposed to be talking about the lifting of the stay and the approach to possession proceedings following the stay. But with the extension of the stay and frankly, late night, last minute regulations, we were worried that our advice would be obsolete as soon as we gave it. So instead what we're doing is we're focusing today on warrant cases. And there are two big reasons why these cases are important at the moment. So the first is that Practice Direction 55C does not apply where there is already a final possession order. So no requirement for a reactivation notice in those cases. And the second big reason why these cases are going to be the ones that come up is that the courts are going to have to prioritise. They're dealing with a huge backlog of cases. They have very, very limited capacity. And they have been told by government that they need to be prioritising the most urgent cases. Now, with that in mind, it's expected that the first cases that come to court are going to be warrant cases. They're going to be cases where there is already a possession order. Now, we are delighted to have with us today Alice Irving, who is the newest member of the housing team. She's a junior tenant who joins us from 1 Crown Office Row. And I hope that over the coming months, you will, or many of you will get the opportunity to see just how capable she is. So we are delighted to welcome her. Can we have the next slide, please? So I will be talking first about landlord applications where there is already a possession order. Then Alice is going to be speaking about tenant applications, and her presentation is focused on the applications that a tenant might make before eviction. So applications to suspend the warrant, applications to bring post-possession order counterclaims and so on. And then finally, Jim Shepherd is going to be speaking about applications after a person has already been evicted. So that's going to be applications for re-entry, but also as part of that, applications to set aside a possession order. Can I have the next slide, please? So, next slide, please. CPR 83.23 deals with the cases where a landlord needs permission in order to issue a warrant. So you'll all be aware that the normal process is you get your possession order, and if it's an outright order, you merely wait for the time for possession to elapse. And if it's a suspended order, then you wait for there to be some breach that would entitle you to possession. And in normal circumstances, the landlord just files their N325 and they set out the circumstances of the order and they get the warrant back in the post, I suppose, from the bailiff's office. And that's an administrative act, so there's no judicial involvement in the decision to issue a warrant in those circumstances. But there are some circumstances in which the court's permission is required and which a judge's decision is required. And the three that are going to come up most commonly for us are, first of all, where 6 years have passed since the possession order was made. Secondly, where there has been some change in the parties that are entitled to enforce the possession order. And thirdly, where it is some sort of conditional order, other than the payment of rent. So you'll all remember the complete havoc that was caused a few years ago when Cardiff and Lee came out, and we thought that in every suspended possession order, there was going to need to be an application. Well, we now know that that's not the case in rent arrears cases, but it is the case where you're looking at some other condition. Normally, this is going to be in antisocial behaviour or nuisance cases. Have the next slide, please. So when an application is made to issue a warrant, It's a normal application process. So it's an application made in accordance with Part 23, but there are some specific requirements of things that are needed. And these are set out at 83.24. So the application must identify the order to which the application relates. Well, so far, so easy. Although, astonishingly, sometimes landlords do get that wrong, but that part of it should be straightforward. Setting out the amount of money that was owed at the time of the order and the amount that was owed at the date of the application notice is filed. Where the application falls within 3A, so that's 6 years having passed since the order was made, state the reasons for the delay in enforcing the judgment or order. And where it falls within 3B, so that's a case where the landlord's interest or the tenant's interest has been transferred, usually it's going to be the former, then you need to explain what those changes are. And in any case, the landlord must give sufficient information to satisfy the court that they are entitled to execute the warrant for, to execute the possession order. Can I have the next slide, please? Now, these applications can be made without notice. And of course, they often are made without notice. But if they are made ex parte, then the normal obligations on an ex parte application apply. Now, anyone that does antisocial behaviour injunctions will be well aware that landlords quite frequently play a bit fast and loose with the obligation to put all relevant circumstances before the court on ex parte applications. And frankly, courts do often allow a great degree of latitude to landlords in those situations. But in my opinion, when we're talking about all relevant circumstances, that is going to include things like, do any children live in the premises? Are there any people with vulnerabilities in the premises? And in the context of coronavirus, we're going to be looking at, well, how has that person been affected by coronavirus? Is that a reason why, for example, a suspended possession order has been breached? Really, that information has got to be there. If you're going to be making an ex parte application and you're going to be asking the court to determine this application on the papers, that is information that absolutely must, in my view, be before the court. And if it's not, then there would be grounds, I think, for setting aside any order given permission. Can I have the next slide, please? So what happens if the application isn't made? Well, we've got a discrepancy in the law here. We've got a bit of a conflict. So when Hackney and White came out quite a number of years ago now, Hackney, the Court of Appeal held that to seek to enforce a warrant without going through these procedural requirements was a very serious matter, that it was an abuse of process, and that any warrant issued without fulfilling these procedural requirements was effectively a nullity. And that's because essentially it hasn't been before a judge. It's only been before an administrative officer of the court. So it's ultra vires. It's a nothing. And in Hackney and White, the Court of Appeal also held that Order 37 at Rule 5, which is obviously part of the old provisions, couldn't recover a warrant which was otherwise void. And so moving some years further on, when we get to AA and Southwark, the Court of the High Court in that case held again that essentially such a warrant is ultra vires, it's not valid, and therefore an eviction which is carried out in pursuance of that warrant is automatically unlawful, and it's an illegal eviction, and damages can be awarded. Can I have the next slide, please? And you can see the reasons for this. So this is AA and Southwark, where a warrant has been issued administratively without the landlord first obtaining the permission of a judge to issue it, in circumstances in which the order for possession had been made 6 years or more prior to the issue of the warrant. So that was the issue in that case. It was invalid, and its issue was not a mere irregularity. The requirement to obtain leave is a very important one, And since after a gap of 6 years from the making of an order for possession, whether that order has been suspended for part or most of the intervening period or not, it is necessary that there should be a judicial inquiry into all relevant circumstances. So that's, you're looking also at the whole of the period of time, so the whole of the 6 years, not just explaining about why it was that you didn't get it in just before the 6 years had elapsed. You've got to explain that whole 6 year period. Can I have the next slide, please? But here's where the conflict that I referred to earlier is. So Cardiff and Lee, when it went to the Court of Appeal, and as I said earlier, we'll all remember this in relation to rent arrears cases and conditional orders, but it also considered more broadly what the effect of failing to apply for and get permission was. And by this time, Order 37, Rule 5 had been replaced by CPR 3.10, but it was in exactly the same terms, really. And it essentially was holding that where there was some sort of irregularity, that the order wasn't invalidated. Now, as I said a moment ago, in Hackney and White and then in AA, it was held that, well, it wasn't a mere irregularity, it was absolutely fundamental. But, to go to the next slide, please, in Cardiff and Lee, the Court of Appeal held the opposite. It said the warrant was not invalid unless the court so ordered. The issue of the warrant was therefore voidable and not void. Applying 3.10, as I say, which is in exactly the same terms. Can we have the next slide, please? I will try to explain what this is. What's going on here? Well, first of all, it might be that Cardiff and Lee is just wrong. It doesn't mention Hackney and White. It's unclear whether the Court of Appeal ever had, whether the judges ever had their attention drawn to that case or to AA and Southwark. So we have here two completely inconsistent decisions of the Court of Appeal, and it appears that Cardiff and Lee may be per incurium. But there are also some factual distinctions which mean that that we can distinguish the two, and in many cases it will be perfectly possible to say, well, actually Hackney and White should be preferred in these circumstances. So first of all, Cardiff and Lee was a case where the tenant applied to discharge the warrant prior to execution of the warrant. And at that point, the court had before it all the information that it needed to determine the landlord's application to rely on the warrant. It also, in Cardiff and Lee, it was also more of a procedural issue. So Cardiff and Lee was simply about, had a conditional order been complied with or had it not? And if it had not been complied with, then there was no sort of exercise of discretion to be had. Whereas the difference is that in Hackney and White, well, first of all, it was, the issue was coming before the court only after the tenant had already been evicted. So at the time of the eviction, there was no valid warrant. But the other point is that when we're looking at a 6 year case, there is much more of a sort of judicial involvement. The judge has got to make an evaluation of whether or not it is appropriate and just to be enforcing the warrant, to be enforcing the possession order so long after it was made. So there are distinctions that can be made, but there's no getting around the fact that there are sentences in both cases which are just flat out irreconcilable. And that's just where we are. Can I have the next slide, please? So moving on to cases where there is more than 6 years that has passed. And the normal rule is that a landlord is not entitled to execute, to enforce a possession order more than 6 years after that order was made. And the case law is quite clear as to that. The burden is on the landlord to demonstrate that it is demonstrably just to do so. There must be some circumstances that take the case out of the ordinary. So it's very much an exceptional circumstance and not one which should, for which permission should routinely be given. And arguably the type of circumstances in which it would be reasonable to enforce a possession order after 6 years might be, for example, where there have been a number of suspensions which have carried all the way through the 6-year period, so that it's never really been away from the court. But I think even in those circumstances, if you've got a period of, let's say, 3 out of those 6 years where nothing happens at all, then it's really going to be an uphill battle for a landlord to get that to get that application to succeed. Can I have the next slide, please? So this is continuing on from Dwyer and Fraser. So these are the sort of things that the court needs to be taking into account. But it says in that case that absent very special circumstances, the court will have regard to such matters as the explanation given for not issuing during the initial 6-year period, and for any delay thereafter in applying to extend that period, and any prejudice which the judgment debtor may have been subject as a result of such delay, including any change of position. The longer the period has been allowed to lapse since the judgment, the more likely it is that the court will find prejudice to the judgment debtor. And I think really something that's really important in these cases is that if the landlord was starting the claim afresh, of course, there would be notice, there would be a pre-action protocol, there would be all sorts of things which would or should give the tenant the opportunity of putting things right. If you're just going to seek a warrant, all of that is gone. So there's very, very clear prejudice to a tenant in enforcing an old possession order as opposed to a landlord issuing a fresh claim. Can I have the next slide, please? Cases, the second circumstance which we come across every now and then, although certainly less frequently, is cases where the landlord's interest is transferred. So usually this will be where housing associations merge or amalgamate or are bought out by another housing association. And there's been quite a lot of movement in recent years in terms of many of the bigger housing associations effectively buying up or acquiring a lot of smaller housing associations. Now, in those cases, there's 2 stages effectively. So the first stage is for the court to substitute the parties in the proceedings. And normally what happens is that the landlord applies to the High Court for what they call a global substitution order. And that substitutes the parties in every case in which the existing landlord was a party. But that's only part of it, because that doesn't deal with the application under Part 83. That application still has to be made because there has been a change in the parties. Can I have the next slide, please? Conditional orders. I mean, this is probably pretty obvious, and I don't think I really need to address this, but the important point here is that it doesn't apply in rent arrears cases anymore. Can I have the next slide, please? Transfer to the High Court. So this is moving on to a different subject, different sort of landlord application. There isn't very much to say about this, but there are some changes coming into force on the 20th of September. Alice is going to touch on this very, very briefly too. But what I need you to recognise at the moment is simply that a tenant is not going to get notice anymore. So it was the case since 2017 that a tenant would get notice of the application being made to the High Court. That's gone from the 20th of September, and instead they'll get notice at the point of the eviction being ordered. Have the next slide, please. I'm going to whiz through this slightly, but these cases, Manchester and Finn, Sheffield and Hopkins, these are the cases where typically possession is obtained on grounds of rent arrears, and subsequently the landlord decides that actually they want to evict this person because of some antisocial behaviour. Now, sometimes this happens because the 2 departments haven't actually spoken to each other. So quite often you get allegations of antisocial behaviour being dealt with by one department and rent arrears being dealt with by the Revenue Department, and Revenue obtain the possession order on rent arrears grounds, and unbeknownst to them, there are also all these other allegations going on. So sometimes it's a lack of communication, and sometimes it's just a timing issue. So the possession order has already been obtained, and then after that there start being allegations of antisocial behaviour. Now, I foresee quite a lot of these applications because they get around the problem of having to issue a reactivation notice. They get around some of the delays in the system that there are going to be about applying for possession orders. And they're going to be the sort of cases which courts are going to want to prioritise because they are generally involve antisocial behaviour. So I think there's going to be quite a lot of these. Now, the really important thing to remember with these cases is that, again, there are kind of two stages. The first stage is the landlord even entitled to rely on these new matters at all? And if we can move to the next slide, these are this is the exercise of the discretion. So as I said, the first stage is the landlord actually entitled to rely on these new allegations at all? It is by no means automatic. So often you get landlords that really forget about this first stage, and they start going on about how there's all this nuisance and all these problems, but actually they haven't actually got that permission first. So if we can go on to the next slide, these are the factors that the Court of Appeal in Sheffield and Hopkins said needed to be considered at that first stage. So is the landlord even entitled to rely on these matters? And the most important is that the discretion should be used to further the policy of, in that case, the Housing Act 85, that a tenant should only be evicted where a ground for possession has been established and it is reasonable to do so, and the tenant has breached the terms of any suspension of the possession order. Now, in my view, what this effectively does is it means that you have got possession proceedings within possession proceedings. So yes, you already have a possession order, but the landlord has still got to establish that the ground is made out and has still got to establish reasonableness on those new grounds. But there are other issues which the court will need to have regard. First of all, the practicality of dealing with it. So often these cases can become really procedurally frustrating and complicated because it's not a mechanism which is best placed for dealing with brand new disputed factual allegations. And the second one that I wanted to draw attention to is, again, whether or not those new matters have actually arisen after the possession order or could have been raised at the time. And this is going back to the point that I made earlier about how you often have two different departments. So if you can say, look, you were well aware of all of this stuff at the time of the possession order, you elected not to rely on it, you chose not to rely on it, and you can't now be bringing it up. If you thought it was that important, you should have relied on it at the time. Now, in truth, it probably is just a more sort of administrative failing than any actual decision. But nonetheless, a housing association, a local authority, is expected to act as one unit, as one entity. It's not expected to be able to say, well, I didn't know what my mate in revenue was doing. We have the next slide, please. Well, there we go. I have finished my bit, and I get to hand over to Alice Irving, who's going to talk about pre-execution tenant applications.
Brilliant, thanks so much, Sarah. Before I get into this, I just wanted to flag that, as Sarah said, we did put off that possession webinar, given the likelihood that the situation might change in relation to the various requirements when the stay is lifted, before the stay is lifted on the 20th. But we are having that webinar next week on the 17th, on the Thursday, and hopefully they don't change anything between the 17th and the 20th. So we should be able to give you an update on those changes. If I could have the next slide, please, Jim. So this is just an overview or a roadmap of what I'll be covering today, because after all, I am a barrister, so there are 4 points I will be covering. We can pop on to the next slide, please, Jim. I'm sure that you're all very familiar with the power to stay or suspend the warrant. The headline here is obviously that this power, which exists in relation to different tenancies under different pieces of legislation, is available where the possession order has been granted on a discretionary ground, but is not available in relation to cases of mandatory possession. But I'll be talking a little later about what you can nevertheless do at the warrant stage if a possession order has been granted on mandatory grounds. There is one change that Sarah briefly foreshadowed that's worth mentioning nevertheless in this familiar context, and that's this. there is no longer any need for a landlord to apply to seek permission to transfer the case to the High Court for it to be enforced by the High Court enforcement officers. They will still need to apply to transfer, but they don't need to apply for any permission. The offsetting aspect of this and the change to the rules is that now, where previously a High Court enforcement officer didn't need to provide any notice prior to eviction, they will be required to provide notice of 14 days, and this will be in a prescribed form. It'll either be posted through the door or affixed to the door of the property where the person is going to be evicted. Now, the relevance of that for the present context is this. It means that if you have a tenant who gets a notice of eviction by a High Court enforcement officer, you've now got a 14-day window in which you might be able to make an application to stay or suspend the warrant. Although we don't foresee that this is going to arise very often given the costs of going to the High Court and the fact that private landlords may no longer pursue this route given that they've lost any advantage because they have to give 14 days notice now under the new regime. If we could have the next slide, thanks, Jim. And again, this should all be very familiar to you. So this is just one example of one of the powers to stay or suspend execution of a possession order. And you'll note that the conditions that will be imposed, there will be conditions if there's a rent arrears issue. And as I'm sure you'll be aware, the likely condition there will be the need to pay weekly rent plus around $375 or $380 if you've got a benefit recipient as a tenant. But I'll gloss over that fairly quickly because we're probably revisiting very familiar ground. So if we could go to the next slide, please, Jim. So technically, there are a couple of authorities that say that there will need to be fairly compelling circumstances where you're applying to suspend a warrant where the initial possession order was a final or an outright possession order, or where you're applying to suspend for a second, third or fourth time. However, in reality, the courts are generally willing to give tenants another chance, provided they can show some prospects of remedying their default. Although obviously, as the number of suspensions you apply for increases, the court will take more and more persuasion. So we've got a trite statement there from Southwark and St Brice about the burden of proof being on the tenant. So you're going to want to turn up with some kind of basis for saying that the tenant is able and willing to comply with any conditions going forward. It's also worth noting that it may be necessary to apply for an adjournment where there is some kind of outstanding dispute. And so the example we've given there is Irving and Powell. So in that case, there had been a suspended possession order requiring ongoing payments to be made by the tenant, and the landlord said that those requirements had not been met and a warrant was issued. The tenant applied to have that warrant suspended and the case was adjourned because there was an outstanding dispute as to the level of rent arrears, and particularly there was difficulty around determining the housing benefit entitlement of the tenant in that case that needed to be resolved. So if you have a case where you want to suspend the warrant but the factual background is somewhat unclear, you may also be looking to apply for an adjournment. Can I please have the next slide, Jim? The other thing to bear in mind is this: if you've got something more substantive to deal with, for example, what we've just spoken about, where there's an ongoing kind of outstanding dispute about the underlying factual circumstance, or, as I'm going to go on to address later, if you have an application such as trying to bring a new counterclaim at the stage of the warrant, or putting in a public law defence or anything like this, it may take some time for that application to be determined. In these circumstances, you're going to want to also ask the court for a stay on the warrant using either of these powers here, because you don't want it to be a situation where the hearing of the substantive application doesn't happen until your client has already been evicted. And the way that you would go about this practically is to make it very, very clear when you're applying that you're asking for a sort of a two-stage process. So you want a short hearing to be listed as soon as possible to deal with gaining a stay in relation to the execution of the warrant, and that only needs to be a 5-minute hearing. But you should be flagging to the court when you're applying that that's all you're wanting to do at that 5-minute hearing, that you don't want them to deal with anything more substantive, so the judge doesn't get sort of up in arms about, oh, you're asking me to deal with a counterclaim or an application for permission to counterclaim, I can't possibly do that now. Then you'll be looking for a later listing to deal with a substantive issue. and hopefully by then you'll have sort of held the position of the tenant safely until that substantive matter can be dealt with. Can we have the next slide, please, Jim? As I'm sure you're aware, the situation is different in relation to mandatory possession cases. You can't get a stay or suspension using the powers that I've just discussed. And any kind of postponement for date of entry is going to be no later than 6 weeks after the making of the possession order, which in practice, you're not going to get to court before 6 weeks after the making of the possession order anyway. So basically there's very little on the face of it that you can do in mandatory possession cases, but not all is hopeless. If we could go on to the second or next slide, please. Sorry, Jim, if we could have the next slide. Success. Thank you, Jim. So one of the first things to note is the case of Diab and Countrywide Rentals. If there's any ambiguity at all about the grounds on which the possession order was made, whether that be mandatory or discretionary grounds, then it should be assumed that it was made on discretionary grounds, and you're going to have the ability to apply for a stay or to suspend a warrant under the powers I covered at the beginning of this presentation. Now, that uncertainty or lack of clarity might be on the face of a single order itself. It might just be unclear about the ground on which the possession order was granted, or it may be the case that there are multiple sort of orders in play, and that it isn't apparent which of those takes precedence, and they contradict one another. In either of those cases, if there's a discretionary ground sort of in the mix, you can argue that therefore Diab applies, and you should be able to use the power to stay or suspend the warrant. Next slide, please. Even if there's no hope of using Diab to get out of the fix with mandatory possession orders, there are a few other options. So these are things I'll be covering in a bit more detail shortly, but you can still apply to the court to discharge any warrant that's been issued. And this might be on any number of grounds. The first might be that it would be a breach of public law to enforce the warrant. And in that case, you'd be applying either for the warrant to be discharged and or for a declaration to say that enforcing the possession order in the current circumstances would be unlawful on public law grounds. And I'll talk about that in a second. Similarly, you might apply to discharge the warrant on the basis that it would be oppressive or abusive for the possession order to be enforced. And I understand that Jim will be covering some of that case law in more detail. And similarly, you might apply for the warrant to be discharged on the basis that it would be discriminatory to evict. Now, there is a little bit of sort of difficulty around this as follows. In theory, on the face of Section 89, which we saw earlier, the court has no power to stay or suspend a warrant. But it would be my suggestion that in circumstances where you are bringing a plausible defence or application to discharge the warrant on one of these grounds, that the court would have an inherent power to stay the execution of the warrant until the substantive application of the application to discharge the warrant had been dealt with. If that's an argument you're going to be making, there's probably going to be some words exchanged on the point at first instance when you're seeking a stay, but the process would be to apply to discharge the warrant alongside making an application to stay the execution of the warrant. If we could move on to the next slide, thanks, Jim. So in terms of the various defences that you may raise at the warrant stage, there's a common thread that runs through the following slides that address some of those defences, which is it's not necessarily going to be the case that you can just throw defence in at warrant stage that you haven't raised earlier. If that matter has been dealt with earlier in a possession hearing, for example, and fully aired, and a possession order has been made, and there's been no change of circumstances, you're not going to be able to relitigate the issue at the warrant stage because that would be an abusive process. Similarly, if you could have raised the issue at the possession order stage and haven't, there may be difficulties raising it again. And you'll see on each of these slides as we go through that there are cases that speak to that in relation to each of the different defences that I'm dealing with here. In relation to public law defences, the most useful defences at this stage might be, for example, a legitimate expectation defence, where you're saying, well, my client, the tenant, received a letter from the landlord saying, well, we won't evict you if you comply with these conditions. We did comply with those conditions. We have a legitimate expectation we wouldn't be evicted. You might also have, for example, a failure to comply with Section 11 of the Children's Act, which is the need to have regard to safeguarding and promoting the welfare of children. So any of these points might arise at the warrant stage, and you'd be challenging the decision of the local authority to enforce the possession order. And as I mentioned before, you'd be seeking either a discharge of the warrant and or a declaration saying that they can't enforce the possession order. I've got a little note on the slide here saying you would normally go through this process just in the county court proceedings. Now, technically, you could also apply to the High Court for a judicial review in parallel and stay the proceedings in the county court in the interim, but this is obviously very cumbersome and it would be incredibly unusual to do this. Nevertheless, remember that in your arsenal, you have the sort of slightly scary pre-action protocol letter in the judicial review procedure that you can send to a landlord if they're being a bit of a stick in the mud and you want to sort of try to force them to be a little bit more reasonable. If we could have the next slide, thanks. Similarly, you might raise a discrimination challenge at the stage of a possession order being enforced. Again, we've got at the bottom there the case law telling us that if this has been fully aired at the possession hearing stage and a possession order has been made and nothing has changed, that's of relevance, you cannot relitigate the issue of discrimination at the warrant stage. Nevertheless, you might apply to suspend a warrant on the basis it's discriminatory if something that has changed. A circumstance that would often arise in this context is Section 15, discrimination arising from disability claim. And this basically would be where the reason why the landlord is evicting the tenant is in relation to behaviour or something that is arising from or as a consequence of the disability of the tenant. I'm just mindful of time, so I'm not going to give you a rundown of the discrimination law there. I'm sure that you're familiar with it. Next slide, please. And almost for completeness rather perhaps than for practical use, you might also raise an Article 8 challenge at the warrant stage, although as I'm sure you're aware, it's fairly difficult to succeed on these claims in the possession context. The same principles apply. You can't raise this at the warrant stage if that would amount to an abusive process. Next slide, thank you, Jim. Final slide, and perhaps one of the more important, relates to counterclaims at the warrant stage. This is one of the most successful tactics to resisting or having a warrant suspended and resisting enforcement of a possession order. Normally you'd be seeking to bring a counterclaim for disrepair, but there's no reason why you can't consider bringing a counterclaim for breach of quiet enjoyment, harassment or discrimination, noting that there can be awards of compensation for the latter two there, as well as for disrepair. And Rahman and Sterling credit tells us that you can bring that counterclaim at the warrant stage, and that delay in bringing that counterclaim is not necessarily a bar. There are a list of factors in CPR 20.9 about what the court will consider when you apply for permission to bring a counterclaim at this stage. But the headline would be this: it's not really a question of whether the tenant is going to get to bring this claim. It's a question of whether it's going to be dealt with in the same proceedings as the possession matter is being dealt with. And in most cases, it'll be obviously more efficient for a court to deal with the matters together, and it would also be inequitable for a landlord to be able to evict a tenant where there's an outstanding dispute, which may result in an award of damages that could be offset, for example, against rent arrears. Procedurally here, if you are in difficulties with time, you might want to file an application for permission to bring a counterclaim without that counterclaim being drafted, and then follow up with that as soon as possible, as long as you've got that with you before you hit the hearing. By the time you're at the hearing, you're going to want to be able to tell the court how much you think the counterclaim is worth. Now, I'm aware of utilising valuable time, and we need to get to Jim, who is going to talk about what happens after somebody's been evicted. What can you do? So I will hand over to him. Thank you.
Brilliant. Thanks very much, Alice. Just move on to mine. Thank you very much. That was brilliant. I mean, I think the point about the counterclaims is very relevant, particularly in the situation that you know, that I've been on several occasions where you turn up at court trying to convince a judge, and the same applies to re-entry applications. You know, as much as possible, do the work beforehand and get your case laid out, because the court needs to know precisely what your case is worth. There are a lot of canny district judges who won't be satisfied if you just turn up and make submissions in relation to disrepair. You need to produce the counterclaim. Anyway, I'm going to look at what I've called the real Lazarus applications. I don't know if you remember when tolerated trespass was a thing a while ago, and it was kind of dominating housing law. And if you became a tolerated trespasser, you could make what was called a Lazarus application. So the phoenix rising from the ashes. And that meant that your tenancy was revived and you were no longer, you know, the lowest of the low, the tolerated trespasser. But these kind of re-entry applications, which I think that's what Lambeth County Court certainly used to call them, we used to have quite a lot of them. Re-entry applications are the real Lazarus applications, because people, you know, who are evicted are on the street. They want to get back into their home. And often it's been their home for years and years. So somebody comes into your office and says, you know, I've been evicted. This is after the stay's lifted, when there may be quite a lot of evictions without notice or consideration by landlords, even social landlords, because they've waited so long to get back on track that somebody just gets evicted, and then that person will come in and say, I shouldn't have been evicted. They promised me that you know, that they wouldn't evict me if I paid the rent, and I did. So what can you do? Well, there's various things you can do. One is nothing. One is something, and it really depends. That's the point. You need to look at the facts of the case. There are cases in which nothing can be done. So if somebody's had a trial at which the client was represented, an order's been made, and it's been properly executed, there's no prospect of appeal, you might just have to, you know, say there's nothing I can do, or at least you may be able to, if they've paid the rent up, for instance, you may be able to rely on the goodwill of the landlord, particularly if it's a charity, you know, a charitable housing trust, and say, you know, can you just not let her back, you know, or him back? Yeah, they pay their rent. So everything that you did before, yes, it was relevant, it was legal, but they've now caught up. Can't you let them back? Sometimes they will, not always. But in this talk, short talk, I'm going to focus on the cases where you can do something, where there really is something that can be done in order to get your client back into the property. And believe me, these are the most satisfying cases probably in the whole of the housing law realm of cases, because you're getting, well, possibly succession, when you win on a succession case, you're getting something valuable for the client, which they don't have because they're on the street. So you probably know that once the eviction's taken place, the court's powers are limited. So what Alice was talking about, the suspension type application, you can't do that because the warrant's already been executed. So you can't go back on that. So, you know, there's no power under statute. It's really largely judge-made law. So first of all, does the court have jurisdiction even? Well, yes, it does. And there's three ways in which the court has jurisdiction. So you can set aside the possession order, which led to the warrant, as long as you act fairly quickly. Although, you know, I've certainly dealt with cases where the possession order is months old, and the court have been satisfied, notwithstanding that, that the possession order can be set aside. Secondly, the warrant's been obtained by fraud. That's obvious because fraud unravels everything. So if you can show fraud, it's very difficult, by the way, to do that. But if you can show fraud, then everything going back to the point where the fraud occurred is unraveled, you get your client back in. Or there's been an abusive process or oppression in the execution of the warrant, which is probably the most interesting bit, and I'll come on to that shortly. But first of all, the first stage, or the first possibility, seeking to set aside the possession order where the client has failed to attend the hearing. And it's very often, you know, our clients are vulnerable, they haven't received correspondence, or they've received correspondence, they've put their head in the sand, haven't dealt with it, or they've got learning difficulties or mental health difficulties, which have meant that they just simply haven't dealt with the case or engaged with it. So what do you do if they haven't turned up to the court hearing? And indeed, if a client comes in to see you, the first thing you do is look at whether they actually attended. If they didn't attend, are you acting promptly? How long ago was the court order made against them? And note that, you know, in quite a lot of cases, clients don't realise that a court order's been made until they're evicted by the bailiffs. You know, that's because they haven't engaged with anything. So the promptness is really, it's talking about what they call alacrity. So it's when the client becomes aware of it, how quickly do they act? So, for instance, if they've had mental health difficulties as a result of not taking medication, and they've only really just started taking the medication and become aware of what the situation is, if they then consult solicitors and seek to get the order set aside, then that's, I would argue, acting promptly. Did they have a good reason for not attending the trial? Well, it's a bit like the Denton criteria. You've got to have a good reason. It's not, just simply there was something good on telly, so I didn't turn up. You've got to have a good reason. It may be, the client couldn't travel to court for whatever reason. If they just simply didn't have any money or whatever. So as long as you can provide a witness statement outlining what the good reason is for not attending the trial, and perhaps the most important, had a reasonable prospect of success at trial. So unless, in a ground 8 case, for instance, unless there was a real prospect of the client actually clearing the arrears or getting the arrears below 8 weeks, then they're not going to have had a reasonable prospect of success at trial. But all 3 requirements must be met, and that's the case of Regency, Rolls and Carnell. You're probably well familiar with the case that says that these cases or these possession claims, the first possession claim is not a trial pursuant to section 39.3. So does 39.35 even apply? Well, the case of Binney says, in fact, CPR 3.12M applies, which allows the court to manage its process according to the overriding objective, and that's wide enough to give the court the discretion. But then following on from that, the case of Hackney and Finlay said, well, actually, when you're exercising that discretion under 3.1, you should consider the criteria in 39.35. So it's really done a circle. So it is, the hurdles in 39.35 have to be addressed in your witness statement and skeleton argument and everything else that you put before the court. And really the corollary of all of the criteria have to be met and it's quite an important case, I think, Bank of Scotland and Pereira. And I think Paul raised the issue as to whether oppression could be raised in mortgage cases. Well, this wasn't a mortgage case, but obviously oppression can be raised in a mortgage case. This was a case about setting aside a possession order, and is a good case to refer to in relation to a set-aside application, particularly in relation to Article 6. because if all those criteria are met, then the court ought to make the order, because it would potentially be a breach of Article 6 if the client is not able to have a fair hearing in relation to the possession case, which they didn't attend. What about if the client did attend and you haven't got enough to appeal? Well, there's this, sorry, let me just deal with this point about Denton. Just in relation to, if you meet all the criteria in 3935 to set aside, you also have to meet the Denton test. So that's the added hurdle, if you like, since the case of Denton came out. So you have to have your eye on both tests. To some degree, they're overlapping, promptness, etc., and realistic prospect. But you do have to address both in your skeleton argument. But what about when the client does attend the hearing and you can't appeal? Well, there's this interesting provision 3.17, which the White Book, I think, takes about 3 or 4 pages to address, because it's fairly complex in terms of the case law. And it's basically the court has the power to vary or revoke an order under CPR 3.17. And it's really, the case law started with a fairly small first instance case, Scandia Investments versus Arga Hansen, where the court said, well, it may be possible to set aside an order, even when the client attends, but you might have to show some material change of circumstances, or that the person who made the order earlier was misled in some ways, whether innocently or deliberately, as to the correct factual position. Well, I've had that situation where the tenant's gone to court on their own, the landlord's given some information, and it's incorrect. In which case, if it's relevant and it led the court to make a possession order in a particular situation, e.g., a landlord saying, "Oh yes, the deposit's protected," when it isn't protected, then that's misleading the court, and potentially you can get that order set aside. I'm not going to get into the distinction between final orders and interim orders, but that is an interesting read in the White Book. If you get a case on where 3.17 is being used, then you need to get on top of that. The leading case is Tibbles, and there's various different criteria that have to be met. It's very difficult to set aside a final order, but you may be able to set aside an interim order, for example, an injunction or whatever. Just moving on. The other area that is interesting and arises quite a lot in housing, I think, is setting aside based on capacity, lack of capacity. And really, you're looking at the Mental Capacity Act, Section 2 and 3. And a recent case of Wiggins, 2019 case, said it was very important that the medical practitioner or the applicant addresses all of the factors in Section 3, even to discount them. But they need to address all of the factors in Section 3 of the Mental Capacity Act. I know that the certificate of capacity that is used, the standard form, does address all of the issues, but I think it's important to remind medical practitioners that they need to address everything. And it's certainly not a given nowadays that a landlord will just accept a certificate of capacity. I've had sort of mini trials based on, does this person have capacity, even if you've got a consultant psychiatrist saying that they don't. A landlord will challenge that and get their own evidence, and then you have a mini trial in terms of the battle of experts, if you like. And so it's not a given that you will get the possession order set aside. It's really 21.3.4 that where your set aside provision comes into play, CPR 21.3.4. So any step taken before a protected person as a litigation friend has no effect unless the court orders otherwise. So what does that mean? Well, it means if a possession order is made at a time when somebody doesn't have capacity, then unless the court orders otherwise, the possession order goes. And then you have to get a litigation friend appointed. But as I say, it's not a given, and certainly a lot of social landlord lawyers are alive to these issues. And whereas it used to be the case that the order was simply set aside and everyone agreed that the OS needed to be involved, that's no longer the case in my experience. It's become more a litigious area. What about oppression? Well, as I say, I think it's the most interesting because as is always said and was quoted in the case of Sarfo, there are no real limits on arguments in relation to oppression because each case has its own circumstances, and some cases the circumstances are bizarre and you can focus on those particular circumstances. It's not always the classic, the landlord promises not to evict somebody if they pay their rent. There may be other things, other forms of criticism that you can raise in terms of, what conduct is oppressive. So their cases are helpful, but they're certainly not determinative. And it's an open situation as to, whether the landlord has behaved oppressively. It's judge-made law. There's no statute on this. It's often a high hurdle, however, to surmount to show that there's truly been oppression in the execution of the warrant. So, if the landlord during the tenancy has not behaved well, that's not enough. You've got to look at how the landlord behaves in the execution of the warrant. And as I've said, much depends on the particular facts and circumstances. And it's vital, therefore, that you gather the evidence at an early stage because your case is based on the facts. As I say, the law is helpful in terms of similar cases, but it's your case that matters. Most social landlords, in my experience, are now aware of the requirement to inform their tenant of the rights to seek a suspension of warrant. So you don't normally have that opportunity to say, well, it was oppressive because the landlord didn't tell me to go to suspend the warrant. But I had a case recently where the landlord, on the day of the eviction, the tenant said, I'm going to make an application this morning. And the landlord continued with the eviction. And we were able to satisfy the court. This, amongst other things, contributed to oppressive conduct because the landlord should have waited until the warrant application was heard that day, rather than just going ahead with the eviction. So, as I said, the categories of oppression are not closed. There's plenty of opportunity for new cases. And Paul wrote a question about whether oppression applied or whether there were other cases in relation to mortgage possession and whether there was going to be more law in that area. Well, I would encourage Paul to share his case with LAG, where he managed to get re-entry on a mortgage case. There will be mortgage cases out there where people have managed to satisfy the court as to that the landlord's conduct was oppressive in exactly the same way. But remember, it's not just oppressive conduct by the landlord. It can be by the court. And interestingly, in relation to the new development Alice highlighted about requiring the High Court bailiff requiring sheriff requiring to give notice to occupiers. Obviously, if they don't do that, then potentially that's oppression on their part. There has to, however, be somebody that's open to criticism. Stephen Naffler valiantly tried to satisfy the court in the case of Jefferson Homes, where his client had cleared all of the rent and rent arrears, and the landlord still went ahead with the eviction. He tried to say, well, that's just unfair, and unfairness equals oppression. And the court said, no, that's not enough. It's not enough that it's unfair. you know, a lot of things are unfair. It has to be more than that. It has to be, somebody must be at fault in some way. So these are the sort of cases, you're probably familiar with most of them, so I'll just briefly go. Saint is an interesting case. That was where the tenant was in prison. The landlord knew he was in prison. They sent correspondence to his home knowing that he was in prison, and he was evicted, and obviously that was oppressive because somebody had decided we're going to write to him at home even though he's in prison. Sarfo was a case about housing benefit where the housing benefit was delayed through no fault of the tenant, and there was actually somebody, one of the officers, a bit like what Sarah was saying, one arm not knowing what the other one was doing. Somebody wrote on the tenancy file, stop possession proceedings, please. But they didn't, and they proceeded with the eviction, and also they failed to follow their own policies on rent arrears. So there was a couple of items of oppressive conduct. Lambeth and Hughes, where the notice of eviction advice obtained from the housing officer was oppressive, but also interestingly, the bailiff in that case failed to warn the tenant in enough time for her to be able to vacate, and that in itself was oppressive. And again, Lemme didn't involve landlord oppression, it involved the court office, where the tenant went into the court office and said, you know, they wanted to seek a stay, and the court said, well, there's no warrant, so there's no need for you to seek a stay. And of course, there was a warrant, and they were evicted. And as I say, the case of Jefferson Home and Mosjeff's just a reminder that there has to be some fault on somebody's part. It's not enough just to be unfair. So, in summary, if you're going to pursue one of these applications, you need to look closely at the evidence, identify where the landlord and/or the court can be criticised, identify how that act has prejudiced the party, usually not difficult, they've been evicted, and prepare a detailed witness statement to accompany the application. Very important. Finally, very briefly, and because it doesn't happen very often, but abusive process. Sarah's dealt with the 6-year type cases, but there are extreme examples of abuse, and it's an interesting case was AA and Southwark. I don't know if you remember this, it wasn't that long ago, where there was actually, the court found that the housing officers had got together and decided that we're going to evict somebody, whatever. And the court found that there had been a conspiracy to evict and misfeasance in public office on the part of the officers. And just to mention there of the case of Nicholas versus Secretary of State, which I think Sarah mentioned earlier on in relation to whether the permission to enforce a writ had been applied for. Thank you very much, and we will deal with any questions now. Back to you, Sarah.
Thank you very much, Jim and Alice. So we do have a few questions. The first one, Jim has perhaps already dealt with, and that's the issue of applications for re-entry in mortgaged property. I might give Jim a minute to have a think about that one, but I will come back to that one in a moment. I've got a question for Alice, and this is from Richard Hazel, and he says, £3.75 or £3.80 per week? The age-old question. Has the speaker heard of TPDs from Universal Credit at 10%? So, Alice, if you want to answer that one.
Yeah, certainly. Thank you, Richard. So the first thing I would clarify is in relation to that initial rate of $3.75 to $3.80. There's nothing in statute that sets that rate as the acceptable rate for arrears to be paid off weekly when you've got a suspended order. But Social Security law generally sets out that that's the maximum deduction, and that's been applied by the courts. That law, so the Social Security law rate is $3.75, and some courts choose to uprate that to $3.80 or $3.85, given that that law hasn't changed in some time. When it comes to third-party deductions made by the DWP from a person's benefits, such as their universal credit. You're correct, Richard, in saying that the guidance states that the rate of deduction has to be between 10% and 20% for rent arrears. So the minimum deduction can be has to be 10% of the standard allowance of universal credit, and that can be a real problem for clients in certain circumstances. So, for example, if you've got a tenant who you're representing who's chaotic and unreliable, and it's difficult to convince a court that they will pay off arrears themselves and manage their financial affairs, you might want to be able to give them the assurance that the client will be able to comply with paying off arrears by saying, well, we'll make it a third-party deduction. But it can be very difficult to essentially take that route because the deduction, the minimum deduction is so high at 10%. It might nevertheless be appropriate to consider this where the arrears are very, very high and where the tenant would be left with a reasonable level of income after that deduction. But obviously, given how tight the standard allowance rate for universal credit is, it's going to be a really tough call in a lot of cases whether that's going to be the way forward. So that's one difficulty, certainly with certain tenants that you might be representing.
I'll unmute myself. Thank you for that, Alice. I'm going to hand over to Jim now for this issue about re-entry and mortgage possession cases. And Paul has added to his question to say fraudulent documents alleged not to be signed by the mortgagor and guarantors and lack of National Crime Agency action currently any views. And actually this is something which, for those of you that don't know, was in the news just yesterday. I think over the course of the last year or so, the BBC has been investigating the allegation that in many thousands of cases, mortgage lenders have been forging signatures on claim forms in mortgage possession cases. And so I think what Paul is asking is whether that is potentially something which is fraud and which might give grounds for re-entry. So I'll hand that over to Jim.
Yes, it is. And you know, definitely, you know, the fraud would unravel everything, potentially. Obviously, the ins and outs of the, you know, the criminal process and to what degree there is criminal liability, I wouldn't like to comment on because I'm not a criminal lawyer, but it does sound like fraudulent to me. And I think it's going to be a gross embarrassment for a lot of banks. In relation to the oppression question that Paul sent about whether there were other, as I said, mentioned whether there were other cases of, you know, mortgage where people have been evicted by the mortgagee. There is no, you know, there's no restriction on oppression arguments to a straightforward landlord and tenant relationship. It's oppression in the execution of the warrant, and if it's the mortgage company that has applied for the warrant, then you know they can be the defendant in much the same way. So you know that is you can certainly run mortgage cases in relation to oppression. I've certainly heard of it, as I said earlier, Paul. I would encourage you to share your case with LAG, who still, as far as I know, still do the housing reports. Sarah also raised quite an important point about promptness, which I think I should just chip in with, which is that, of course, under the practice direction 51Z, time doesn't run for the purpose of any rule. And so, you know, where we had promptness, or the situation of promptness, potentially you may be able to argue it doesn't start until the stay is lifted, in terms of, you know, whether you've behaved promptly. Slightly difficult argument, I think, but potentially that is arguable, I think.
Now, Jim, I'm afraid I have two more questions for you. So the first is from Judicial Domicide, who asks, what type of force can be used by bailiffs and or High Court enforcement officers or agents at eviction? And they often threaten violence or try to drill locks out. Is this legal?
No, I mean, I don't think it is. And I think the Criminal Law Act is your recourse. They don't have the right to do that. There was recently quite a useful document put out by Liberty. It wasn't in relation to bailiffs, but it's the same sort of principles about what the police can do when trying to deal with COVID breaches. And I think the same applies to bailiffs, that they don't have the right to force their way into the property. They often do force their way into property, but it's by invitation only. That's certainly my understanding. And usually people let them in, and that's the end of it. But they do overstep the mark, and we certainly, John Hobson, a colleague of mine in Chambers, has brought cases, both against the police and bailiffs. So it is possible to bring cases against bailiffs if they overstep the mark in relation to certainly the Criminal Law Act.
Mm. And what about drilling out the locks?
Well, so I think the same thing applies, because they're not entitled to cause criminal or cause damage to a property in that way in order to gain access. But my understanding, I say I'm not a criminal lawyer, and it probably comes within the Criminal Law Act, is that the forcing of a lock would constitute a breach of that act. And bailiffs are really only allowed to enter by invitation. That is my understanding.
And something I would just add to that, and I'm not really sure whether this is a legal issue or perhaps more to do with the guidance or training which is given to county court bailiffs, but I certainly have had a number of cases in which the bailiffs have refused to carry out an eviction because they have found somebody who is so mentally unwell in particular. And I can think of probably 3 or 4 cases in the last 2 years where that has happened. So I don't think it is all that uncommon for bailiffs to refuse to carry out their instructions and to do the eviction. And we have a question from Jensen Lamb, and he says, could Jim explain in a little more detail why you need to apply for relief from sanctions at the same time as when you apply to set aside?
Well, because your failure to come to court is in effect a breach of an order, and you're asking the court to give you relief from that. So because you have your client has an invitation to come to court. They haven't come to court for whatever reason. It might be perfectly good reasons, but in effect, it is a breach of an order, and so you have to. Belt and braces requires you to apply the Denton criteria as well. I don't think it actually involves much work, because a lot of the same hurdles are crossed when you are dealing with 3935. But I think it is something that you have to have in mind.
Thank you. Now we've just had a question in from Rachel Lovell, which Alice, you can deal with if you want to, or it's quite a short answer, I think.
Yeah.
But Rachel asks, re-raising a counterclaim at the warrant stage, say for disrepair, if the landlord had already obtained an outright possession order on mandatory ground 8 for rent arrears, and you are not applying to appeal or set aside the possession order, then how will bringing a counterclaim at the warrant stage assist you? I'm unclear how the court will have any power to stay execution of the warrant in this case to allow your counterclaim to be brought. The landlord already has the outright possession order, so even if the county court could now bring the level of arrears below 8 weeks, clear them, this is irrelevant, can still rely on the outright possession order to evict you, the same as if you had reduced, cleared the arrears by any other means, such as from your own money. I had thought bringing a counterclaim at the warrant stage would only assist in discretionary ground rent cases. To which the short answer is yes, you're absolutely right, Rachel. It won't help you.
So
but if there's anything you want to add to that?
No, just to say, if you go back to the slide deck, you'll see that when it comes to that slide about things you can do where you've got a mandatory possession order, you've got your public law, you've got your discrimination, and you might have oppression and abuse, but you don't have counterclaim on that slide. And sorry if I wasn't entirely clear that counterclaim would only be useful in the discretionary context. I wonder, Sarah, if we might also address Rachel's earlier question while we're here.
So Rachel asked, Rachel's other question is, what if you're applying to set aside the possession order itself, which was granted on mandatory grounds, or even appeal the possession order? Do you believe the court has power to suspend the warrant until the appeal or set aside is heard? This seems to happen routinely in practice, and I have not had any issue obtaining this.
Yeah, I think the court does, because if you set aside the possession order, then it's as though it never happened.
Yeah.
So, you know, that the court will have that in mind. I mean, so, you know, if the possession order is set aside, then the warrant goes, and so you're not in the same territory as, you know, like trying to suspend a ground 8 possession order. You're not actually doing that. What you're doing is setting aside the original order that was made, you know, on whatever ground. So if, for instance, you were able to argue that, well, a ground 8 possession order shouldn't have been made because you had a set-off against the order in relation to disrepair, then I think the court does have power to suspend pending that hearing, not through Section 9, but through its own the court's own powers of managing its own business, a bit like the old cases about right to buy, and whether you have you know, whether the right to buy application comes before the possession hearing, etc., etc., where the court can manage its own business in that way. If you've got a case in which, you know, potentially the order should never have been made because there was a set-off which would have meant that there weren't 8 weeks arrears, then I'd say the court does have power to suspend pending that application.
Alice, is there anything you want to add to that?
Not really, other than to point listeners in the direction of the Powell case in the Supreme Court, which deals with the court's inherent powers to manage its own business in this kind of situation. Jim is
absolutely, yeah.
Thank you. All right, we've got a whole load more questions. I'm not sure we're going to be able to deal with all of them. So let me try and be a little bit selective. Daniel Jones asks, if a tenant exhibited the symptoms of COVID-19, possibly self-induced by putting pepper up their nose, I think this might be an actual case, Daniel Jones. Do you think the bailiff will go through with the eviction as a matter of practice, and also the bailiff's contract of employment? Interesting. Probably not a tactic that we can recommend, nevertheless a tactic that tenants might want to consider for themselves. I'm not sure that's really legal advice, but does anyone want to add anything to that?
Not really. I mean, I would be amazed if the bailiff didn't go ahead with the you know, I mean, I've had clients who've got COVID symptoms who've had closure orders made against their property. So I doubt whether the bailiff's going to shirk the responsibility, to be honest.
I mean, most areas only have a couple of bailiffs that are carrying out all the evictions. So, yeah. I mean, I suspect it very much depends on who you get.
Yeah.
There will be some who are gung-ho and very wedded to evicting people, and there'll be others that are more sensitive. But yeah, you could give it a go. Shaw Nowers, I hope I'm saying that right, asks, resetting aside possession order under CPR 39, On appeal against the refusal of the set-aside application, is the judge hearing the appeal limited to the original circumstances, or can fresh evidence and information be presented? I think that's you, Jim.
Yeah, well, yes, it can, if fresh evidence, and you can meet the criteria in the relevant case, which Sarah will remind me of, about fresh evidence in an appeal, which is completely gone from my head. But
Adam Marshall.
Ladder Marshall, if you can meet the Ladder Marshall criteria, then it seems to me that what you're looking at is it isn't a rehearing. You'd be looking at whether the original judge was wrong to not set aside the order, and so it's quite a high hurdle in relation to that. But then, you know, in fact, it's, you know, I say it's not a rehearing, but it will turn into one, because essentially you're producing to the circuit judge or whoever your appeal court is all the same evidence and saying, look at this, you know, how could any judge decide that you know, that this order should not be set aside, and therefore, you know, it was wrong. So, you know, whilst it isn't strictly a rehearing, you've got to satisfy the court that in effect the judge was irrational. You are necessarily going to produce all the same evidence that you've had below, plus any new evidence that you want to produce under the Ladder Marshall principles.
We've got another question here, and I think I might have to wrap it up there. But I'm not sure we can answer this question, but Michael Linan asks, whilst bailiffs have not resumed actioning warrants and are not due to do so until 23rd of September, the government issued bailiff guidance regarding seizure of goods. Do you believe the same type of guidance will apply? And there's a link. We've been given a link to the guidance on bailiffs during the COVID-19 pandemic. I haven't had a chance to look at it, so I'm not sure what it says, but does anyone want to comment on that?
I just wanted to say I've only just opened it myself, but as Michael's clearly pointed out, that is guidance that's specifically in relation to seizure of goods, taking control of goods process. As such, it wouldn't have any direct application to eviction from properties, but unless the government issues something that's directly on point, I would suggest that there wouldn't be sort of any basis to say that someone would have to follow this guidance, although you might point someone to it as an example of potential best practice. But I'm not sure you would have any potential legal standing of any sort, given that it's obviously in a different context. Do the others agree with that kind of general?
Yeah.
I mean, I think in practical terms, all you have to do to repossess a property is change the locks. That's all you have to do. So you don't have to engage in all the sort of touching of personal items that you would have to do when you're seizing goods. So it is a slightly different thing which is being done. My view is it's going to vary a lot between bailiffs and how they choose to work, but I suspect a lot of them just put on a mask and get on with it.
That's
Anything
right.
else? All right, in that case, we will finish up there. Just to let you know, as Alice said, we have got another seminar coming up next week on the lifting of the stay and possession proceedings more generally, so for those cases where there isn't already a possession order. So we'll be sending out details of that probably pretty shortly. So it only remains to say the slides will be available on our website, I think probably in a few days' time. So will the recording of this presentation. And if you've got any questions, please feel absolutely free to send us an email and we'll try to answer any further questions. Sorry we didn't get onto absolutely everything. So if there's anything that you have a burning desire to discuss, absolutely feel free to send us an email and we'll do our best to go through it. So thank you very much, everyone, and goodbye.
Thank you.